Hello, everyone. For folks joining, we'll get started in about a minute. Hello, everyone, and welcome to the Environmental Law Institute's event, Community Lawyering for Environmental Justice, Part 8, Title 6 as a Tool for Advancing Environmental Justice. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. I want to thank all of you for joining us this afternoon, as well as give a massive thank you to our wonderful speakers who have prepared a fantastic program today for all of you. Today's event is the 8th part of our Community Lawyering for Environmental Justice series, designed for attorneys to receive continuing legal education credit through practical education about the practice of law in relation to environmental justice. We've created a worksheet to go along with this event, so please be sure to download the written materials from our event webpage. We will post the link to that in the chat. I want to take a minute or two to go over the continuing legal education component of this program. ELI is an accredited CLE provider in Vermont and Pennsylvania, so this program is automatically approved for 1.5 hours of standard CLE credit in those states. ELI has not applied for CLE credit in any other states for this program. So please check your state CLE guidelines to see if your state offers reciprocity with the states in which we are pre-approved. If you're seeking CLE credit in a state which does not offer reciprocity with Vermont or Pennsylvania, then you'll need to apply for CLE credit individually with your state bar. Within approximately 1 week of this program, we will email out certificates of attendance to anyone who requests one and who fulfills the requirements. Certificates of attendance are used to verify attendance for CLE purposes, and in many cases, attorneys can use these to apply for individual CLE credit with their states. To receive a certificate of attendance, you must be online throughout the entire program. We'll be verifying this with our software's attendance report. You must also fill out the certificate of attendance request form after the webinar. This was already sent out via email to all registrants before the program, but we'll also post a link in the chat in case you missed the email. And finally, you must submit the correct code in the certificate of attendance request form to verify your attentiveness. We will read the code out loud and post it in the chat at some point during today's program, so please be on the lookout for that. Should you have any questions related to CLE, please contact us at cle@eli.org. Today's program is recorded and posted publicly to ELI's website and YouTube page. Additionally, we will be taking audience questions at the end of the program, so please feel free to put your questions in Zoom's Q&A box as you think of them. While the chat will be open for you to post your observations, please put any questions that you would like our speakers to address in the Q&A box, not the chat. I will now go ahead and turn things over to our wonderful moderator, Zoe Vogel, who will get us started today. Zoe's currently a public interest legal fellow here at the Environmental Law Institute and previously served as a law clerk at ELI during the summer of 2022. Zoe received her JD with honors from Tulane University Law School, where she served as the editor-in-chief for the Tulane Environmental Law Journal, a student attorney with the Tulane Environmental Law Clinic, and an intersectionality chair for the Environmental and Energy Law Society. During her time there, she also held positions with the National Wildlife Federation, the Tulane Institute on Water Law and Policy, and Louisiana Center for Planning Excellence. You can find all of our speakers' biographies on the ELI event webpage as well. Zoe, I will hand things over to you. Thank you so much, everybody.
Thank you, Madison. Hi, everyone. Thank you all so much for joining us today. My name is Zoe Vogel, and like Madison said, I'm a fellow here at the Environmental Law Institute. I'd like to start with a huge thank you to our education team who works so hard to put on such great programming. I'd also like to shout out our pro bono clearinghouse team who puts on this community lawyering series. More information on the clearinghouse can be found at eli.org/pro bono. As Madison said, if you have any questions throughout the presentation, please put them into the Q&A box, which you can find at the bottom of your screen. We have time at the end reserved for answering questions, but please put your questions in there as you think of them. There's no need to wait until the end. I am so pleased to be moderating this panel on Title VI as a tool for environmental justice. We have a really excellent group of panelists presenting here today. Like Madison said, I will be sharing abbreviated bios with you all, but links to all of our speakers' full bios can be found on the event page. Our presentations will begin with Amy Laura Khan, who will be giving us the history of Title VI and some insight into its importance as a tool for advancing environmental justice. Next, Lisa Jordan will present on Title VI in Louisiana and discuss the current ongoing litigation in the state. Miriam Jordan will then present on the Title VI landscape in Louisiana before and after that litigation, and we will finish with Debbie Chisor, who will present on her Flint, Michigan Title VI complaint. We will then have plenty of times at the end for questions, so again, please put those in the Q&A box as we make our way through the program. Like I said, we'll begin with Amy Laura Khan. Amy Laura is the legal director for Taproot Earth, a community-based movement lawyer with over 25 years as an organizer and facilitator. Amy Laura collaborates on environmental, climate, land, and food justice to support self-determination and shifting power. Amy Laura is an adjunct lecturer at Tufts University and the University of Pennsylvania Carey Law School. She is a member of the Jewish Voice for Peace National Board, the Penn Law Alumni Advisory Board for Inclusion and Engagement, Alternatives for Community and Environment's Legal Advisory Board, the editorial board of Journal for Environmental Justice, and the Title VI Alliance. With that, I will pass it to Amy Laura.
Thank you so much for that introduction. Thank you so much for having me. It's great to be with a bunch of dear colleagues for this conversation. So as Zoe said, I'm going to talk a little bit about the statute, its history and potential, and also outline some of the key barriers to enforcement, or as far as I can get on those barriers in the time that I have. Title VI of the Civil Rights Act of 1964, along with other civil rights laws like the Fair Housing Act, like Section 504 of the Rehabilitation Act of 1973, which covers disability discrimination, has the potential to be one of the most salient tools to remedy the harms created by racial segregation and environmental racism, and to fill at least some of the gaps in our environmental, energy, and property and land use laws and their failure to address cumulative and disproportionate impacts. Title VI applies broadly to prohibit discrimination by recipients of funding from all federal agencies, including our family of environmental agencies. And it is one of the bases for Executive Orders 12898 and 14096 on environmental justice. There's a long history of Title VI as a tool for law and organizing in the environmental and climate justice spaces. And as a result of this advocacy, President Biden and EPA Administrator Regan have committed to enforcement of civil rights in the environmental and climate justice contexts. These rights exist, and the challenge is really how to enforce them. So the statute states that no person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. The statute followed on the decision in Brown versus Board of Education. Title VI was intended to invalidate funding statutes that allowed for separate but equal distribution of funds or provision of resources, and to establish that federal agencies could enforce non-discrimination policies, provide uniformity across agencies rather than including this prohibition in every funding statute, and expressly prohibited federal subsidies of discriminatory practices. So the intent of Title VI was to invalidate both intentional discrimination and actions with the effect of discrimination, or what we call disparate impact, based on race, color, or national origin. And we often point to a quote from President John F. Kennedy from 1963, prior to the passage, speaking on this point, where President Kennedy says, "Simple justice requires that public funds to which all taxpayers of all races contribute not be spent in any fashion which encourages, entrenches, subsidizes, or results in racial discrimination. Direct discrimination by federal, state, or local governments is prohibited by the Constitution, but indirect discrimination through the use of federal funds is just as invidious and should not be necessary to resort to the courts. And it should not be necessary to resort to the courts to prevent prevent each individual violation. So from the beginning, a prohibition against both intentional discrimination and disparate impact as part of the legislative history. Demonstrating the power of this law, we saw that 1 year, or perhaps prior to my existence, but those who were around for the passage of the Civil Rights Act, saw 1 year after President Johnson signed the Civil Rights Act into law, he secured passage of Medicare, which provides financial support to hospitals for medical care to seniors, a cost that had previously gone uncompensated. And one history of the passage of that law describes as follows: with one stroke, more than 7,000 hospitals were subject to civil rights regulations set forth in Title VI of the Civil Rights Act. So really, a powerful law if enforced. So who's protected and who is held accountable by Title VI? Title VI broadly prohibits discrimination, exclusion, or denial of benefits on the basis of race, color, or national origin. And just to unpack that a little bit, it protects all persons in the United States, and person regardless of immigration status. So not just citizens, but all persons in the United States, and that includes private entities, but might not include cities. Race, color, or national origin includes perceived race, color, or national origin. And national origin includes an individual's accent, ancestry, birthplace, culture, immigration status, or language. So Title VI is a tool to advocate for language access and to ensure broad language access in the provision of programs that use federal funds. It covers recipients of federal financial assistance, again, broadly defined. So grants, loans, detail of federal personnel, use of federal property, although maybe not tax exemptions, which is relevant in this moment, in this era of the Inflation Reduction Act. And then a recipient may be a public entity, a private entity, or an individual. Includes primary or sub-recipients and direct and indirect recipients, including universities who are recipients through federal student loans. And then most importantly, or maybe not most importantly, but importantly, prohibits discrimination broadly in any program or activity, any part of which receives federal financial assistance. So this has been interpreted very broadly. The legislative history states that when any part of a state or local government, department, or agency is extended federal financial assistance, the entire agency or department is covered. So an agency can't just for one program receive financial assistance and comply in that context, but once that federal financial assistance is received, then that whole agency really has to comply. And the website usaspending.gov is a great window into who is receiving federal financial assistance from what agencies. So it authorizes every federal department or agency that gives financial assistance to issue rules and regulations, and authorizes them to effectuate compliance by terminating or refusing grant funding or by any other means authorized by law. So, of course, it's not that simple. There have been significant barriers to enforcement, the most significant being the US Supreme Court's decision in Alexander v. Sandoval in a 2001 decision written by Justice Scalia, a 5-4 decision. In that decision, the court found that there is no private right of action for individuals or communities to enforce Title VI unless they can prove intentional discrimination. So the challenge of enforcing civil rights law in the environmental justice context is exacerbated because an individual or community cannot go to court unless they can prove intent. And as folks know, racial bias is often implicit, unconscious, and even where it is conscious and intentional, intentional discrimination is very hard to prove. So the impacts of Sandoval were seen immediately. Sandoval itself was not an environmental justice case, but the Third Circuit quickly applied it to an environmental justice case called South Camden Citizens in Action versus New Jersey Department of Environmental Protection. In that case, the District of New Jersey had found that New Jersey DEP's permit for a cement plant had a disparate impact on the majority Black community in South Camden in violation of Title VI. This is a community that had been overburdened for years. It was well documented in that case. And in 2001, the Third Circuit found that it is clear, particularly in light of Sandoval, Congress did not intend by adoption of Title VI to create a federal right to be free from disparate impact discrimination. So immediately, kind of one advocacy opportunity for environmental justice communities was immediately shut down. And the US Commission on Civil Rights found in 2003, regardless of the perspective of Sandoval's value, environmental justice complainants immediately had one less avenue of redress, and thus found that strong administrative enforcement of Title VI was required. So the problem is that we have not seen strong administrative enforcement of Title VI. There is the power to do so and the mandate to do so. Agencies are authorized to effectuate rules and regulations to enforce Title VI, and every agency has interpreted the word discrimination to include both intentional discrimination and actions which have the effect of subjecting individuals to discrimination. Each agency is charged with investigating complaints, ensuring affirmative compliance before giving out funds, and setting forth clear standards. And agencies have the power to withhold federal funds and refer cases to Department of Justice for enforcement, although the statute allows for negotiation and voluntary compliance. We have not seen the withholding of federal funds or the referring of cases to DOJ in the environmental justice context very often, although we have in select instances under HUD and Department of Transportation. But overall, unfortunately, in the absence of a private right of action, severe and longstanding deficiencies in civil rights enforcement and oversight have enabled funding recipients to permit waste and fossil fuel facilities and infrastructure that exacerbate racially disproportionate pollution burdens, approve transportation projects that split communities of color, and deny equitable participation of people with limited English proficiency in siting and permitting decisions. There are severe systemic barriers to agency enforcement across the board, but in particular, it's been well documented with EPA over many years. There's a series of reports starting in 2011 with a Deloitte internal audit, actually starting with the US Commission on Civil Rights report in 2003, and then again in 2016, outlining the systemic barriers to enforcement and a record of poor performance. Historically, a lack of case management system, a lack of staff to enforce Title VI and other civil rights laws, and a chronic unresponsiveness over many years. There has been advocacy also over many years coming out of environmental justice communities and in partnership with folks who are actually in the room with us today to enforce the federal mandates to enforce Title VI. So in particular, there was a case filed in 2015 by Earth Justice and others on behalf of communities around the community in New Mexico and Michigan, Alabama, California, and Texas, as well as the National Sierra Club, bringing to the court's attention that complaints were languishing with EPA, and that EPA for over a decade, and that EPA was failing to respond to complaints or resolve them, even in compliance with its own regulations. And the plaintiffs in that case actually succeeded, and there was a consent decree to hold EPA accountable to meeting its own regulations and to respond to complaints. There have been other systemic issues, for example, a failure historically to include community members in the investigation and resolution of complaints, and a historic, although recently corrected, decision by EPA, which said that compliance with environmental laws led to a rebuttable presumption that there was compliance with civil rights laws, although EPA more recently has rescinded that. In 2020, to bring us to this moment, in 2020, the EPA Office of Inspector General did a report that outlined, again, the systemic issues with an EPA failure to enforce Title VI, finding that over 80% of funding recipients lacked required foundational elements on their websites to a civil rights program, that EPA was not conducting compliance reviews and association with grant funding, and that overall there was a real systemic issue and a real lack of even understanding by state personnel as to how to comply. We've seen the prior administration did not respond positively to that report in 2020, but we saw a real kind of 180 under the Biden administration in 2021, with a renewed response to that report, saying, really acknowledging all of those systemic issues, and outlining a kind of work plan in 2021 in terms of what EPA was going to take on to bolster the program. And I think that is probably a good time for me to wrap up and hand over to my colleagues to talk about how that's really operationalizing in this moment. What are some of the current barriers that persist? Where have we potentially seen some progress? But the one thing that before I hand off, that I will say is that one kind of incremental improvement we've seen through EPA in particular is the publishing of its Title VI docket. And once I'm done, I'll put the link to that in the chat or the Q&A, because it gives, for the first time, we're actually able to see Title VI complaints from 2014 on and really understand how community members are engaging with the agency around these issues and how the funding recipients are responding. So with that, I will hand it back to you, Zoe, and I'm happy to keep talking about the barriers and the opportunities in the Q&A.
Thank you so much, Amy Laura. I know we already have a question in the Q&A regarding what you're talking about. So if you ask that, I promise we will get to that at the end of the presentation. Next, turning towards more Title VI in practice, we have Lisa Jordan. Lisa Jordan is the director of the Environmental Law Clinic at Tulane Law School in New Orleans, Louisiana. She has over 20 years of experience with the clinic, including serving as acting director in 1999 to 2000, supervising students in the representation of clients who face threats from pollution and barriers to effective participation before governmental entities. From the beginning, Professor Jordan and her students' representation has focused on Louisiana communities disproportionately impacted by industrial pollution. Notably, Lisa and her students represented a grassroots citizen group and their partners for opposing air permits to Shintech Corporation for a massive polyvinyl chloride plant proposed for Convent, Louisiana, a town in the middle of Louisiana's Cancer Alley, where the clinic does much of its work. So I will turn it to you, Lisa.
Thank you, Zoe. Hi, everybody. Good to be here. I think the Shintech case that Zoe mentioned is a good place to start. It was filed in 1997. Amy Laura mentioned there's sort of a long history of using Title VI, and that was a Title VI, that case involved a Title VI complaint alleging discriminatory permitting of this massive polyvinyl chloride plant, which ended up not locating. But the plant was going to be located in St. James Parish, which already had an overburden of industrial pollution. And that was in 1997. So fast forward to now, and that area is worse rather than better. And Title VI complaints have been filed, for those communities and others. And one of the requirements that EPA has for filing a Title VI complaint, and again, by complaint, I'm referring to something that we file with EPA, not in court, an administrative complaint that allows EPA to act based on its regulations that prohibit discriminatory effect. And so one of the requirements that EPA has for filing a Title VI complaint is that the complaint be filed within 180 days of the discriminatory action. So if you're filing it, for example, over a permit that an agency issues, then you would need to file the complaint within 180 days of that permit issuance. There is actually a provision in the regulations that allows EPA to waive that time period, but I haven't found in my practice that they do that. So you certainly wouldn't want to rely on it. But part of the result, I think, of that time limitation is that, at least in our practice, complaints tend to be filed based on permitting. And so they tend to be sort of a putting out a fire, a type of action, right? Like, here's this permit, it's going to result in or exacerbate a discriminatory, disproportionate impact, EPA please act. And so, over years of trying to do these, again, sort of Cancer Alley is worse than it was before. And so our clients in the industrial corridor, which we call Cancer Alley, and is the area along the Mississippi River between New Orleans and Baton Rouge, that has a heavy burden of industrial facilities, along with Southwest Louisiana is another area in the Lake Charles area. So these communities along this river stretch have just been burdened over many years now with increasing facilities, permitted by our state's Department of Environmental Quality. And they got sort of tired of trying to put out fires and largely not really being successful. There are the challenges Amy Laura mentioned. So we filed in 2022 a complaint against DEQ for basically what we referenced as systemic discrimination by the Louisiana Department of Environmental Quality in how it conducts its air permitting. And DEQ is an entity that receives federal funding. So it's subject to Title VI, it's subject to EPA's regulations. And so we filed this complaint in 2022. Right at the same time, actually about a month before that, Earth Justice filed a complaint on behalf of a St. John the Baptist, which is also in Cancer Alley based community, also focusing on DEQ and, in their case, the Louisiana Department of Health, both of which accept federal funding for discriminatory actions that focused on the St. John community and on a particular facility there called Denka, which produces neoprene. So these two complaints came within about 2 weeks of each other. And EPA accepted the complaints, and which basically means it sort of found that the complaints met the procedural hurdles. The agency receives federal funding. It was filed within 180 days of a discriminatory action, and it, and facially it alleged discrimination. So the agency accepted the complaints. And in our case, we were alleging systemic discrimination that was a continuing pattern of violation. So we basically argued that the 180-day limitation doesn't apply. But nevertheless, we did have an action that DEQ took on a facility, a proposed facility called Formosa. We call Formosa Plastics, wanting to locate again in St. James Parish. And it would be a behemoth, and there's state court litigation on that facility as well. But DEQ reconsidered its air permits, and that triggered the 180 days again. But there were a number of other facilities that we highlighted in our complaint to highlight DEQ's sort of systemic actions in discriminating against these communities. And it's arguing both that the impacts are subjecting these communities to a disproportionate levels of air pollution, but also that DEQ just doesn't have a procedure for addressing environmental justice at all. And if you look at DEQ's actions over time, you can see it just has no rhyme or reason to the way it handles environmental justice. It will do different things under different circumstances. Sometimes it won't address it at all. And I'm talking about permitting where it is a community that would be considered an environmental justice community based on race is usually the issue in Louisiana. And so they just either wouldn't address it, or they'd sometimes address it in one way, they'd address it arbitrarily. They were just all over the place in terms of how they addressed it. So it's not only that your permitting is resulting in disproportionate impacts of pollution, but you don't even have a procedure. So that's the complaint. As I said, EPA accepted them, and EPA began its investigation of these complaints. And gathered evidence, talked to the complainants. In both complaints, I think they actually went down to St. John and talked to some of those folks. But they started their investigation. The Louisiana Department of Environmental Quality responded to the complaint. Well, after the complaint was accepted, they filed a response. And then EPA began negotiations with the state to develop an informal resolution agreement, is what EPA calls it. And it's basically a settlement of the complaint alleging discrimination. And EPA began to engage in discussions with DEQ about what DEQ could do to resolve the complaint. And those developed into actual drafts of a settlement, of an informal resolution agreement that was becoming very robust. It had some significant things in it, but it was a negotiation that was ongoing. And so, and we were involved peripherally. One of the challenges I think that Amy Laura may have been alluding to and did allude to directly is historically, and I've experienced this in past complaints, it was very frustrating being involved in an EPA investigation and resolution of a Title VI complaint, because the complainants were basically shut out of the negotiation process. They were part of the investigation. EPA would take information from them, sometimes talk to them, but not about what was going into this resolution agreement. You just would have no idea at all until it was signed on, signed, sealed, and delivered. And then EPA would say, here's what we've done. We're happy to talk to you as many times as you want about what we've already done. So it was really frustrating. And now EPA has been better about at least keeping complainants informed about what's going on. But to receive copies of these informal resolution agreements, we had to do public records requests to the state, which under our Public Records Act gave these to us. They had to. Our Public Records Act is strong in Louisiana, so we were getting them, but not through EPA. So there's still some challenges to participation. But so things were rolling along. EPA actually issued a letter of concern in October of 2022, where it basically said what we're finding so far is disturbing. Preliminary letter, but indicated to the state that its findings were disturbing. But again, IRA discussions going through, and then the state of Louisiana filed suit against EPA and the Department of Justice over its handling of these complaints, and more broadly over its Title VI regulations. That lawsuit was filed in May of 2023. In federal court in the Western District of Louisiana, based in Lake Charles. That was while the IRA discussions were going on. That lawsuit was filed actually towards the end of them. EPA had hoped to resolve the complaints in July of 2023. But the lawsuit was filed, and then the Attorney General also filed a request for a preliminary injunction to stop the EPA from proceeding with its investigation and resolution of those complaints. So that was a very big deal and changed things. So I wanted to talk a little bit about that complaint, because it's still active and it's pending a decision right now, a pretty significant decision. But what the complaint, again, by the state of Louisiana, filed by the Attorney General's office at the time, that Attorney General was Jeff Landry, who is now the governor of Louisiana. The complaint was actually filed by an Arizona-based attorney, but on behalf of the state of Louisiana. And the complaint, as I said, it challenged both EPA's investigation and resolution and handling of the two, actually it's 3 Title VI complaints, because there was the one against the Department of Health that Earth Justice filed on behalf of the St. John community. So 2 against DEQ, and then one against LDH. So what the complaint alleged was basically sort of 3, using the term of the Department of Justice attorney who argued the case, 3 buckets of claims that it alleged. It challenged directly EPA's disparate impact regulations. So EPA's regulations that Amy Laura referred to, that allows the agency to act on a finding of discriminatory effect, which the regulations allow. Basically the case challenged that as unconstitutional and also challenged it under the Administrative Procedure Act. So it asked the court to enjoin those regulations and basically wipe them out, find them illegal. It then also brought a claim that EPA was illegally delegating its authority to private entities. That one was a little off the wall, but a little involved. But basically, there was one of the complainants in the St. John base case was the Sierra Club, which had litigated in the 2015, I think it was litigation that Amy Laura referred to, litigated against EPA for sitting on all these Title VI complaints across the country and not resolving them, and got a consent order that basically said in any Sierra Club related complaint, EPA has to act within a certain amount of time to resolve the complaint unless the Sierra Club agrees for the extension. So the complaint, the Attorney General complaint alleges, well, that was EPA delegating its authority to a private entity. That's that claim. And then the third bucket of claims involves what they're calling extra regulatory requirements that the Attorney General says EPA is imposed on the state as part of these negotiations. And they're focusing on a cumulative impact assessment that EPA wanted the state to conduct as part of, looking into potential discriminatory permitting, to look at the cumulative impact of permitting and not just permitting piece by piece. That was part of these IRA discussions, were involving this cumulative impact analysis, and the complaint alleged that that was extra regulatory. It should have gone through rulemaking, and it was, EPA didn't have the authority to do it. So those are sort of the three buckets of claims. After that lawsuit was filed in May, again, they filed for a preliminary injunction later on, and again asked to stop. And then on June 27th, EPA administratively closed our complaint, the complaint we filed on behalf of the Cancer Alley communities, and the Earth Justice filed complaint on behalf of the St. John community. EPA closed those out. And in the letter telling us that they were closing out the complaint, basically EPA said, we're doing other things outside of our Title VI authority that's resolving these issues. And there are a number of things that EPA is doing involving some rulemaking that would address ethylene oxide and chloroprene, which are some of the pollutants issue in St. John and generally in Cancer Alley, and some RCRA related actions it was taking that would affect the Denka facility, and then referenced the fact that the Formosa permits are actually vacated right now because litigants in state court succeeded in having those thrown out. So it was unclear whether those permits were even going to go forward. And then EPA also said, we're going to do our own cumulative impact assessment in St. John, again, outside of our Title VI authority. So that was EPA's stated reasons for closing the complaint. But the case is going on, although EPA has filed a motion to dismiss based on several grounds, standing, mootness, basically, and just untimeliness of some of the complaints. So EPA filed a motion to dismiss and for summary judgment. The Attorney General has filed for the preliminary injunction, and those motions were just heard on January 9th. And so interesting discussions, but the court did not decide any of those issues, but presumably will. Definitely will, presumably sometime relatively soon, but there's a lot there. And basically EPA's argument is your challenge to these regulations is a facial challenge. You are challenging the regulations as a whole, and you're way too late for that. These regulations were promulgated, I don't know, something like 50 years ago. And so you're far too late for a facial challenge, and it's a pretty hard argument for the Attorney General to say it's not a facial challenge. But so that's their essential argument on most of the claims, that you're just way too late, or you don't have standing because you're not injured. So for example, this claim that we're acting, past our regulatory authority and asking for a cumulative impact assessment, well, that was never done. The complaint was closed. You never had to do it. You don't have standing because you weren't injured, state of Louisiana. So basically that's the arguments. And again, mootness, because the complaints have been closed out. There are no complaints. There actually are no active, well, I don't know about that. Actually, there are now, but at the time, I think EPA filed the motion to dismiss. There were no active claims. There may still not be. I'm not sure about that. But there was another complaint that was filed afterwards that also got closed out. So EPA said there are no complaints. And so this case is moot. And that's where it stands. So we're all kind of waiting to see what the court says. Again, this attempt to sort of wipe out all of the regulations, including the Department of Justice's. So it's not only EPA's disparate impact regulations, but the Department of Justice's disparate impact regulations that's at issue in this case. And what happens here will be very informative about what we in Louisiana can do going forward under Title VI. And so I'll just end it there.
Thank you so much, Lisa. Quick before we move to our next presenter, it's time for me to give the CLE code, which should also be dropped in the chat. The code is all capital CAJH5560. So that's the code for those of you seeking CLE credit. Now, continuing our conversation, we have Miriam Jordan. Miriam is a climate justice attorney at Earthrights International. She first worked at Earthrights from 2014 to 2018, where she worked in both the Amazon and US offices. During this time, she developed international legal and advocacy strategies with indigenous community leaders and grassroots organizations in Peru and Ecuador, and represented clients in human rights litigation against multinational corporations. Before her return to Earthrights in 2022, Miriam served as counsel for the Special Litigation and Advocacy Project at the Lawyers Committee for Civil Rights Under Law, where she supported legal and advocacy strategies in relation to cross-cutting racial justice issues, including environmental racism and anti-Blackness in the U.S. immigration system. With that, I'll turn it over to you.
Thank you, Zoe, and thank you to ELI for this great opportunity to be part of a panel with some amazing speakers. As Zoe mentioned, I was an attorney at the Lawyers Committee for Civil Rights Under Law, which filed the St. John the Baptist Parish complaint with Earth Justice. And, I just remember when I was working with my colleagues at the time on drafting this complaint, this, sense of hopeful energy, especially with the Biden administration's commitment to strengthening environmental justice obligations, and just being really forward thinking on what EPA could do in terms of Title VI compliance, even though the agency had a pretty unfavorable track record, as Lisa and Amy Laura have mentioned. So what's really interesting, when at the time Louisiana v. EPA was filed, my colleagues at Earthrights and I, we were working on another Title VI complaint, or we were drafting a Title VI complaint on behalf of the John Charles Choctaw Nation, which is a tribe located in the southern coast of Louisiana. And when the lawsuit was filed, it was, just became quickly clear to us that we couldn't just solely focus on allegations related to a disparate impact analysis, but that we needed to incorporate stronger intentional discrimination allegations. And so I think, this is one of, my personal takeaways from Louisiana v. EPA is the fact that while environmental justice advocates had traditionally relied on Title VI administrative complaints for a disparate impacts, this is changing the landscape of what we need to include in these allegations. And I know this litigation is still pending, so we have to see what happens. But in the meantime, I think this has created more caution in what we need to include. I'm gonna just provide some background on this Title VI complaint. So even though we've been talking primarily about Title VI compliance at EPA, we recently filed this Title VI complaint on behalf of the John Charles Choctaw Nation with HUD. And I think this, speaks to how, other agencies may play a role when it comes to Title VI compliance for environmental justice and climate justice issues, especially when we're thinking about remedies for communities that are overburdened by the impacts of climate change. Just some, as a factual briefer, the John Charles Choctaw Nation, they are considered among the first climate refugees in the United States. And similar to other tribes in coastal Louisiana, the tribe has unfortunately experienced centuries of discriminatory forced relocation from the ancestral lands, rejection of tribal sovereignty, denial of education and land ownership rights, and environmental destruction from excessive oil and gas activity in the coast. And in addition to these existential threats, the tribe is endangered by the impacts of climate change. Climate change has played a big role in coastal erosion in southern Louisiana, and there's also an increase in dangerous storms such as Hurricane Ida in 2021. And these climate change impacts have made living on the John Charles Choctaw Nation's ancestral lands on the Isle de Jean Charles more difficult. And, unfortunately, there was a lack of interest and investment from the federal government and the state, and the tribe was told that protecting their homeland would be too expensive. And so as a result, the tribe made the painful decision to relocate from the Isle de Jean Charles, and they conceived of and spearheaded the plans for a resettlement program which would reunite the tribe, since many tribal members had been displaced over the years due to hurricanes and other weather events, and to also provide climate resilience for their community. The tribe identified a funding source for their resettlement program, and this was HUD's National Disaster Resilience Competition. Even though the tribe's relocation was eligible for the program, they could not apply directly because they are not a federally recognized tribe. And because they're not federally recognized, they had to work with Louisiana's Office of Community Development. And so this agency applied for a tribe-led resettlement. And in 2016, HUD awarded $48.3 million for the tribe's resettlement program. And this is, I think, a significant amount of money, as you can imagine. And unfortunately, once the money was received, OCD made some drastic changes, and we argue in our complaint that the resettlement went from a tribe-led resettlement program to a bare-boned relocation of inhabitants of the Ile de Jean Charles. And in our complaint, we discuss how OCD removed the tribe status as a beneficiary for the program. They've constructed roughly 30 homes that are not structurally sound, which I think is concerning given that the state received $48.3 million. The state also restricted tribal members' access to the resettlement program, and they eliminated key cultural components in the design plan. We also, in our complaint, discussed the various times in which the state was disrespectful towards tribal members, including someone from OCD writing an article that the tribe should not be called climate refugees. They should instead be considered pioneers, which we find extremely disrespectful given the connotation of the term pioneers. There's also a lot of concern about the state not providing adequate language accessibility for tribal members who have limited English proficiency. A lot of the members of the tribe and other tribes in coastal Louisiana speak Indian French. And another concerning issue that we've highlighted in the complaint is that now that most of the tribal members have moved or been displaced from the Isle de Jean Charles, the state and local parish government invested millions of dollars in infrastructure in and around the island to promote private business development, which is almost exclusively owned by non-Native Americans. And this is very alarming given how before the tribe was informed that it would be too expensive to protect the isle for them to live on. So we filed the complaint last month with HUD, and we argue that HUD's actions evince a discriminatory intent against the John Charles Choctaw Nation as Native Americans, and that their conduct led to a harmful disparate impact on the tribe. And we've asked HUD to investigate OCD for various things, including how OCD has spent the $48.3 million that were allocated for the resettlement. The resettlement is technically still ongoing. In June, the state announced it was announced that a second phase of construction of new homes in the relocation site had begun, but unfortunately, this has not led to the climate resilient relocation that the tribe had originally envisioned when they put together this relocation plan. Given how recently we filed the complaint, we are still waiting to hear how HUD responds, but I think what's definitely on our minds is what the impact of Louisiana v. EPA will mean for HUD's enforcement, even though we're talking about another agency. This is still concerning Title VI obligations in Louisiana. So, we'll see what will happen. I will say that I, just wanted to add some reflections, broader reflections related to the theme of the CLE series, which is community lawyering and environmental justice. And I know that, we are thinking a lot about the challenges of Title VI and, pursuing justice through administrative complaints, but wanted to think more about how this could be an effective tool when we're thinking about the community lawyering framework. And, as lawyers working with communities, we often have to grapple with the fact that the law has its limitations in providing an adequate remedy for harms that a community has experienced. We have to translate a harm to damages or identify injunctive relief that a court will find reasonable. I've also been thinking about how litigation can or limits a platform for communities to share their story. We have to deal with the well-pleaded complaint requirement. And so, I think this is just part of the things we have to think about when we're sharing a community story in litigation. Even though there are a lot of challenges with administrative Title VI complaints, there's some things I appreciate from a community lawyering perspective. I do think that this type of strategy is more accessible. For example, the complaint doesn't have to necessarily exclusively be signed by an attorney, and there's an opportunity for communities to be more involved in the process. I think there's, some leeway with what we can say in a complaint. While, EPA and HUD they both have jurisdictional requirements for their Title VI processes. I think this is an opportunity for communities to share their story and have their truth be told in a way that, is a priority for them. I think that Title VI complaints can be seen as an opportunity for more of a collaborative process between an attorney and a community, especially when we're thinking about the remedies that are requested. I think that communities have an opportunity to list out the types of remedies they're looking for when it comes to obtaining justice. While that doesn't necessarily mean that this will happen in the outcome of a complaint, I think there is power in a community being able to share what it means to secure justice. And I think, as I mentioned earlier, community members can sign on to complaints. For example, in the Title VI complaint that we had just filed, the chief of the John Charles Choctaw Nation signed the complaint along with Earth Rights attorneys. And I think, there's power in having that kind of visibility. And even if a complaint, is not successful or does not move forward, I think that a community sharing their perspective in a Title VI complaint can be helpful for communities in other situations. In the context of the John Charles Choctaw Nation complaint, we're hearing more and more about communities receiving federal funding for climate relocation. And there are a lot of important lessons to be learned from this complaint, especially since agencies are thinking more and more about climate relocation and are starting to consult with communities and other types of stakeholders. And so I think that this complaint can provide some insight to other tribes who are experiencing relocation and what, critical lessons can be learned. I'll conclude on that note. Thank you.
Thank you so much, Mariam, both for the insight into your complaint as well as your reflections. Next, giving us insight into another complaint, we have Debbie Chisware. As the managing attorney for Earthjustice's new Chicago office, Debbie has been building a Midwest team and a docket of cases across 3 program areas: climate and energy, healthy communities, and wildlands and wildlife. This team's work includes representation of tribal nations in the fight against the risky Line 5 oil pipeline and advocacy on behalf of Black low-income communities facing disproportionate environmental harms from air and water pollution. This work builds on Debbie's experience over the last 2 decades, where she has advocated for environmental protection across many issues, fighting for environmental justice in the Midwest at Northwestern Law's Environmental Law Clinic, promoting Great Lakes Health at the Alliance for the Great Lakes, and protecting wildlife and public lands in the Rockies for the National Wildlife Federation. With that, I will turn it to Debbie.
Thank you so much, Zoe, and thank you to ELI for organizing such a rich event and for attracting so many participants from a range of places, public interest, government, and more. It's great to see everyone out there. As Zoe said, I'm going to talk about the work that Earthjustice did in partnership with the Great Lakes Environmental Law Center in Flint, Michigan. And I want to start by talking about our clients. We had 3 clients in this administrative complaint before EPA, and the clients were Flint Rising, a Project of the Tides advocacy group, and they focus on organizing and they were born out of the Flint water crisis. We also represent the environmental transformation movement of Flint, also born out of the Flint water crisis, and a group that's designed to work with community members to promote health and environmental protection in the community. And then lastly, we represent St. Francis Prayer Center, a group that's been fighting for social justice for 40 years in Flint and provides services to community members. You may have heard, I don't remember if Amy listed all of the plaintiffs in the CARE litigation that's been referenced in the complaint, in the chat, but in the Earthjustice litigation about EPA's delay in managing the Title VI administrative complaints, St. Francis Prayer Center was one of those plaintiffs, and that's because it had filed its first complaint of several in 1992 and was still awaiting resolution when Earthjustice filed that lawsuit in 2015. Finally, that case was resolved in 2017, so 25 years later. People know about Flint, they know about the water crisis, but there's so much more to tell about Flint, and our work relates to another component of the story. But before I get to our work, I just want to say that Flint has suffered from community members in Flint suffered from the fact that they were displaced by urban renewal and the building of the massive auto manufacturing complexes like Buick City, and efforts, part of the civil rights efforts were to provide access to more housing in Flint and other communities, and that resulted in 2 housing complexes that were affected in our work. This part of Flint where those housing complexes were built as a result of the civil rights movement turned out to be adjacent to Genesee Township's industrial corridor. Genesee Township placed its industrial corridor in the only Black census tract in the town. And it's no surprise, it won't be a surprise to anyone that it's the area surrounding this industrial park has the highest asthma rates in the state, in the 98th percentile of asthma rates. And I think this has been factored in much of what's been said before, but pollution and other kinds of harmful exposures aren't distributed equitably, and they cause these higher rates of illnesses and impact low-income communities of color more severely than other communities. And that is why, even though our environmental laws are designed to protect everyone, they don't, because there are the concentration of facilities in certain communities leads to more harm in these communities. And the environmental justice movement tries to address that, and Title VI is one tool. So when we were approached in Flint to do this work, it was because yet another facility was going to be located in this industrial park, and hot mix asphalt plant, and it was going to be located 1,500 feet from public housing in Flint and adjacent to the St. Francis Prayer Center. And so we were approached by the three groups I mentioned, and the Great Lakes Environmental Law Center, our co-counsel, to get involved in commenting on this potential permit and advocating and trying to get justice for this community that really didn't need another source of pollution. And for those of you who don't know, hot mix asphalt plants emit sulfur dioxide, lead, yes, I said lead, particulate matter, and other harmful toxics that would face this community. So when I think about our work, one of the amazing things is that, you know, through our advocacy, both EPA and HUD weighed in on this permitting process, and they said, hey, State of Michigan's environmental agency, also known as EGLE, this looks like a problem. You're going to allow a facility to be located so close to housing and in a community that's already facing a lot of health harms as a result of this concentration of industry. You really ought to look more closely before and consider cumulative impacts before granting this permit. Unfortunately, the permit was issued, and on behalf of the three groups, we took on a multifaceted strategy. We had a traditional environmental strategies where we filed an appeal to the issuance of the permit, and then we had our 2 civil rights complaints, which I'll address in a minute, as well as amazing organizing and communication strategies led by our client groups and their allies. I'm going to mostly talk about our complaint filed before EPA, but towards the end, I'll talk about a complaint that's still pending before HUD. So we filed a complaint before EPA, explaining that the decision to issue a permit to this hot mix asphalt plant discriminated on the basis of race against our client groups and the communities. We felt that without considering cumulative impacts or the impacts of this decision in light of all the other facilities, that the state was really just repeating the harm to this community, and as recipients of federal funds, they shouldn't be able to do that. Our complaint was accepted for investigation, and we became part of the pilot program that EPA is doing, where complainants are part of the negotiation process. And we met with both EPA and the Michigan Department of Environment, Great Lakes and Energy as EGLE, as I said before. This is new, as Lisa eloquently explained before. Often complaints would go into a black hole, and residents would never find out what happened until it was all done, signed, sealed, and delivered. And sometimes, as in the case of the St. Francis Prayer Center's complaint, it took 25 years. So we were very thrilled that EPA invited us to participate in the pilot project. And I want to say it took an incredible investment of time on behalf of our clients to show up week after week, truly week after week. We met with them for months on end, week after week, and they had to prepare for that and strategize. And well, on the one hand, it was a beautiful process for our clients to develop creative solutions that would address the harms that the community is facing, it was also a very taxing process that not every community can handle or would want to invest in. And but we were going along and we were optimistic, like Miriam said. I think we also felt the sense of hope that through this process we could transform the way air permitting decisions were made in Michigan. Indeed, our complaint was only one of 4 complaints that were pending in Michigan related to air permitting at the time that our complaint was pending. As everyone has discussed, in May, when Louisiana sued EPA, that was a disruptor to many processes, and ultimately after EPA dismissed or closed rather the complaints that were pending that Lisa mentioned, Michigan also changed its tune, and the ultimate resolution agreement was much weaker than we had hoped. I do want to say that there are, as disappointing as that was, to feel this sense of like a new approach and then a positive development through our interactions and our amazing clients, amazing advocacy of our clients. We did get some changes. So I'm going to talk about those briefly. Part of that was the result of our clients organizing the on-site investigation by HUD and EPA. EPA and HUD came to visit. So that was really had a huge impact on the investigators. And I encourage the agencies that are on this call and also the advocates to make sure that the agencies investigating the complaint get there and meet with people who are impacted. Those stories are still ringing in all of our heads as we go forward. So some of the things we got, the public participation policy will be changed. And while in the past, when Eagle has changed its public participation policy as a result of Title VI administrative complaints, it didn't lead to much change on the ground. We're starting to see a changed way of doing business in terms of public participation. I hope we'll see more of that and that it will become more systematized. Right now, it's dependent a lot on our clients' interactions with the agency. We're seeing more monitoring. We really think many communities, if they were properly monitored, there would be a lot more attention to the harm that people are suffering. So we will see a little more monitoring, not as much as we wanted. And then we were very heartened that US EPA Region 5 is stepping up. And there's already been one enforcement action in the industrial park, and we hope there will be more. So that is one thing that's happened, and a huge credit to our clients who are stepping up and trying to take advantage of some of these changes and really advocate alongside people living in the public housing and in other around the community. But we're not limiting our advocacy just to Flint. The Flint complainants are quite engaged now, and they I know we probably need to move on to questions, so I'll just say we have been doing national advocacy alongside many of the other attorneys on this call, and I hope that through that we will be able to get some systemic changes by EPA and DOJ that will really do more to help communities around the country.
Thank you so much, Debbie. For those of you who missed the CLE code earlier, I just put it back in the chat again. The CLE code is CAJH5560. And with that, it is now time for us to move into the Q&A portion of our presentation. The first question being that is there any case law that provides precedent or guidance for entities about what can be considered effective first notice to the public with regards to the 180 days of the alleged incident? So is there guidance as to what that specific incident triggering that time frame has to be? And I'll just open that up to all of our speakers.
just gonna say, I don't know. I'm looking to my colleagues to say I don't know of any specific guidance on effective first notice. Wish I did.
All right. Second question. And I will turn this to Lisa just because I know that you have filed a supplement to your complaint. In this group's experience, does supplementing a Title VI complaint delay a response to the complaint?
Yeah, in fact, I think we filed supplements in most of the complaints, Title VI complaints we filed. We never seem to be able to say everything the first time when you got 180 days breathing down your neck. In terms of delayed a response, I don't think in terms of a final response, I couldn't say. Because up until the CARES litigation, and even after that, if Sierra Club's not a party, there really wasn't, EPA just didn't really comply with its with what it says in the regulations that it will decide these complaints within, I think it's 180 days. That just never happened anyway, so kind of hard to tell in terms of an ultimate response to the complaint, like a decision or an IRA. It's hard to tell because it just takes a long time anyway. In terms of when EPA is deciding whether to accept the complaint, I haven't noticed too much of a change. I think that we've always tried to include those procedural hurdles to get that right the first time, so that, because those are fairly easy. As Amy Laura said, there's usaspending.gov to look to prove the federal funding, and the 180 days, you can usually allege, you can usually find the final agency action. I would remind the person who put the previous question, there is an exception. If you're sort of, you find you potentially missed a deadline because you didn't have notice of a decision, EPA can waive the 180-day requirement for good cause. So don't forget about that. But I would say that I haven't found any big differences, but I will also say that we usually supplement it fairly quick in time after we file the original, like, within 2 or 3 months.
I can just add that we've been encouraged to provide additional information as, not a formal supplement to the complaint, but continue to provide information to the investigators.
Awesome. Thank you so much. Another one for Lisa. Can you speak a bit more about Louisiana's argument that EPA's disparate impact regulations are unconstitutional?
Wow. In the few minutes I have, okay, I think it's basically an allegation, and I'm Amy, Lauren, Debbie, probably Miriam too, know as much or more as me about the actual legal claims in the case, but they're saying that it's the statute itself, Title VI and Section 601 and 602, that basically the Constitution, the laws in place say that it only prohibits intentional discrimination, and that's Title VI itself. And this is basically coming from some case law that there is really 3 key cases, that the Sandoval case that Amy Laura mentioned, and Alexander versus, I don't know how to pronounce it, Choate, I don't know how to pronounce that. And then the Guardians case. So there's 3 cases where the Supreme Court sort of interpreted Title VI itself, so the Civil Rights Act itself. The regulations, are EPA's exercise of its authority under the Civil Rights Act that Congress gave it. But the state is arguing that Congress did not give EPA the authority to prohibit actions that have a discriminatory effect. That's beyond what Congress allowed. I'm trying to remember exactly the constitutional angle to it. There's a spending clause argument that it exceeds the spending clause. That one I had a little trouble understanding, so I can't really speak about that. But that's that's the main one, and that's the main gist, that they're saying Title VI itself does not allow EPA to do what it did with the regulations. That was not a very articulate way of talking about it, but anyway, if anybody else wants to chime in.
I mean, I think that was just great. And I think also some of the arguments are just confusing on their face. Including an argument that relies on a proposed regulation under the Trump administration that would have done some work to dismantle disparate impact. I think under the Fair Housing Act, if I remember correctly, but was never published. So they rely on policies that were actually never officially promulgated, and that there's some sort of, if I remember correctly, without looking at the complaint, a kind of allegation that the failure of the Biden administration to kind of take up the Trump administration's position on disparate impact was somehow something that could, that could defend their position. So that was somehow an error by the Biden administration. So there are the complaint reaches far and wide, I will say. And I guess to sort of delve into one of the other questions, just to dip my toe into one of the other questions that is coming up in the chat around Justice Gorsuch's concurrence in the SFFA case and whether it raises concerns about the viability of Title VI as an enforcement tool. I think it is important to see the attack on disparate impact and the attack on Title VI as relating to the attacks on affirmative action, that these are two sides of a coin, that there is even as we look to the SFFA case and understand that, it broadly invalidates affirmative action in admissions, in the admissions context, but many policymakers in government, many folks in the private sector are understanding there, or at least anticipating there to be a broader impact of that case in invalidating race-conscious policy writ large, and that Title VI is really the backstop against that. So if we're not able, under the SFFA case, and any sort of, there are still windows of opportunity for race-conscious policy. I want to say that explicitly. There are ways that we can address environmental injustice and the distribution of climate impacts, and affirmatively and defensively, that center race and environmental racism and racial discrimination and the impacts of housing segregation. We still have these tools. So I just stepped on a soapbox, I'm sorry, but we still have these tools, and yet we sort of see the backlash against affirmative actions to directly address the impacts of systemic racism. And Title VI is intended to be the backstop. If we're not able to take those affirmative steps, then we should be able to, under Title VI, address both the intentional discrimination, but also the disparate impacts of, the distribution of disaster resources, for example, or the disparate impacts of permitting, because, so the project to really dismantle affirmative action and our ability to kind of take affirmative steps to dismantle those impacts, and alongside attacks on Title VI are concerning and should be seen in tandem. So I will hand over to my colleague.
Thank you so much. I'm going to group a couple questions together here, if you'll stay with me. One being, if you have a sense of whether local agencies, what their general understanding of Title VI obligations look like, and whether people in government are thinking about it on a day-to-day basis, and whether there's guidance for how they should be reviewing permit applications in order to satisfy Title VI requirements, and whether there's a framework as to when they should approve or disapprove applications, particularly when it meets environmental regulations but may have a disparate impact.
I can jump in to start and then hand off to folks, but I think there's two things that I wanted to note. One is that the Office of Inspector, so in terms of the capacity of local and state governments to comply with Title VI, and not just under those receiving EPA funds, but I think more broadly, I think I find the Office of Inspector General report coming out of EPA really instructive because it talks about a real lack of understanding at the state level and as well as at the local level of how to comply. And a real need on the part of federal agencies to work with their funding recipients to understand what affirmative compliance looks like. And in particular, that report points out a lack of understanding about what, a number of folks on this call have mentioned cumulative impacts. What are the cumulative impacts of multiple pollutants and multiple facilities on communities where they are concentrated, which we know to be communities of color, indigenous communities, low-income communities. And we haven't historically had good analytical tools, nor have we had good, strong laws to address cumulative impacts. The federal government is actually, and EPA in particular, has taken some steps under the Biden administration to really bolster analysis around cumulative impacts. And we have some state models in notably New Jersey and now Massachusetts, and I think New York, that have legislated mandates to incorporate cumulative impacts analysis, which is a really key factor in addressing disparate impacts on environmental justice communities. So I think that would be one place. Two things that I would note is, there has been a really historic lack of capacity, and particularly in the cumulative impacts context, we've got a federal agency that is doing some strong work to try to bolster our tools in that space, and we've got some really strong state models to look to.
Thanks so
I
much.
think
Mary,
so
go
just
ahead.
building off of what Amy Laura said, I do think that this is an opportunity to not just think about the role of the federal government, but how environmental justice standards can be strengthened at a local and state level. And in addition to the states Amy Laura flagged, I'm thinking about the proposed Atlantic Coast Pipeline and how that was challenged by, or some of the permitting was challenged by Friends of Buckingham. And the fact that the state of Virginia did not do an adequate environmental justice analysis, and the Fourth Circuit actually issued a great analysis, discussing how the state failed to take environmental justice impacts into consideration. And this played a role in, nullifying the permits that were issued. And so I think that this is a really helpful example to think of, how in this universe of environmental justice advocacy that, we should look at the federal government to do more, but, there are definitely opportunities to strengthen policies and laws at the state level.
And I just want to quickly add to the meaningful involvement aspect of achieving environmental justice it's not so complicated. And there actually is some guidance that EPA put out back in 2006 on meaningful involvement. And that's an area that I think our state anyway could easily do more on and does not. It's not complicated to figure out, that a public hearing where the person who's making the decision on the permit isn't even present, no one will answer questions, and people just speak into a void is not meaningful involvement. So I think that, I don't know how aware at least our state is on a day-to-day basis, but our state will not meet with members of the community. They won't, and they meet with industry all the time. So I think that's an area of a particular void that there's plenty of information out there about how to achieve meaningful involvement, and should be easy enough to do, but isn't being done here.
Thank you all so much. One final question before we pass it over to Madison for final remarks. This is from the Q&A, and I've also seen multiple people raise it in the chat. Very timely given the arguments heard yesterday, but would EPA's Title VI enforcement authority be challenged under the major questions doctrine, or potentially curtailed if if Chevron deference is eroded. I'll open that up to the group.
I'm just going to mention real quick that the major questions to doctrine did come up pretty prominently in Louisiana's argument before the judge on January 9th. Major questions was something that he said. I think he ended his entire argument with that. So it's definitely been teed up there. I don't know about how directly, but it's definitely been teed up in that case.
Any other reflections on how it would potentially play out, or we'll leave that to the court to decide? All right, thank you.
Oh, I just
go
wanted
ahead,
to,
Miriam.
sorry, yeah, just quickly add, I think it'd be really interesting to, think about the interplay between that and Scalia's analysis of the Title VI statute in Sandoval, where, he clearly states that, with Section 601 or Section 602, the type of, kind of looking at the type of discrimination, whether intentional or disparate impact, and what that means in terms of enforcement. So I think that, to the extent that there's ambiguity on enforcement of Title VI, especially, in the administrative context, I think there could be some tensions with Sandoval, but, I think this definitely opens the door of other aspects of Title VI. I think, going back to what Lisa had said on Louisiana v. EPA and what it means to, define disparate impact and enforce that for states or local entities that receive federal funding.
Thank you so much. At this point, I would like to open it for final remarks from our panelists. If any of you all have any concluding thoughts that you would like to share.
Just want to draw attention to Amy Laura's last note in the chat. I think it's a phenomenal resource that can help advocates and states as they think about cumulative impacts.
And I would just say, I want to co-sign Miriam's comments about really, coming back to the community lawyering nature of this. You listened to a bunch of lawyers, but really, our community partners, our clients, frontline communities are really at the center of, and should be at the center of shaping the narratives of these complaints, should be at the center of what an investigation looks like, and should be at the center of the resolutions. And I think, hat tip to EPA for starting to pilot bringing community members into the conversation, but we really need to kind of formalize and across government how we really center frontline communities in investigating and resolving and really creating the remedies. And we're still a long way from that.
Well, thank you all so much for your time and energy and engagement in this. Us at ELI, as well as I'm sure all of our guests, are super appreciative of everything that you shared with us. And Madison, I'll pass it to you.
Thank you, Zoe. We just want to echo Zoe's thank you. Thank you so much to our speakers, Amy, Laura, Lisa, Miriam, and Debbie, for joining us and for all of the wonderful commentary you all provided on such an important topic. We truly appreciate your time and energy. Thank you to Zoe and to Christine and Jack on ELI's Pro Bono Clearinghouse team as well for their assistance in organizing this webinar and for making a great worksheet for you all as well, which we'll post a link to in the chat. Thank you as well to our audience for tuning in. We so appreciate your engagement today. As a reminder for those seeking continuing legal education credit, please be sure to fill out our certificate of attendance request form. We posted the link in the chat. Additionally, we have two different course evaluations, one that is exclusively for attorneys in Pennsylvania and one for attorneys in other jurisdictions. We'll be posting the general course evaluation link in the chat as well. We'll also send out the general course evaluation and Pennsylvania course evaluations over email, depending on which bar you give us, bar ID you give us. So should you have any questions about continuing legal education credit, please email us at cle@eli.org. Thank you all so much, and we hope to see you at a future ELI event. Have a great day, everyone.
Thank you.
Thanks all.
Thanks, everyone.